I'm going to call Andrew Bailey.
Thank you, Mr. Chair. What a fascinating night. I've sat here and listened intently. I've listened to lawyers, I've listened to accountants, I've listened to political people, and I am just staggered about how people cannot understand a relatively simple piece of legislation. Now, let's just go back to first principles. This act, or this bill, obviously is dealing with a good piece of what's gone on with the New Zealand Super Fund, set up by Dr. Michael Cullen, as we all know. And it does seek to address superannuation for the future and to have a forward fund to be able to pay for it. We all know that it was set up in 2003 and has achieved outstanding results. But what I want to remind you about are the two key underlying principles that Dr. Cullen had for the fund. One was that the fund was going to grow to a size, and we wanted to make sure that it did not have control of markets in New Zealand. And to put that in context, we've now got a fund worth $29 billion, and we know what the New Zealand Stock Exchange was worth, don't we, Mr. Robertson? It's worth about $100 billion. So roughly 29%, if we applied it all to the New Zealand Stock Exchange, would mean we would dominate the stock exchange. So, quite rightly so, we put into place some clauses to make sure that the superannuation fund couldn't control direct investments, right, other than real property. The second thing is we wanted to make sure it was free from political interference. Right. So, this part one of the bill deals with three key issues. So, let's just deal with the first one, which is about permitting fund investment vehicles as an appropriate investment vehicle. Now, it's interesting, right? I don't think many people actually understand what they are. They're actually a very, very common vehicle for fund managers, particularly if you use a fund-of-fund approach. And I'm sure many of you know what that means, but for a large fund like New Zealand Superannuation, you will use professional fund managers to manage certain assets. So, what this bill is doing, after all those years since it was set up in 2003, is to try and modernise the situation at the behest of the guardians of the New Zealand Super Fund. So, these usual investment vehicles, called fund investment vehicles, are now going to be established, right? And the change permits them to be used to hold non-controlling equity stakes in direct equities or investment funds. Secondly, to hold stakes or have influence over managed funds, that example I gave you before, which subsequently invest in equity or debt instruments like treasury stock, government bonds, commercial bills. And the third thing is to hold investments in real property. Now, this is where that little nuance I spoke about before. For instance, the New Zealand Super does hold real property in the form of forests and stuff like that, right? But the Act precludes it from holding directly the shares or having control over the entire equities like a company. So there is a difference between having control of the shares of a company as opposed to having control of the real property like forests, land, all those other good things that the superannuation fund is entitled to and should be investing. So this deals with this. Now, the other thing I heard today, or early this evening, was all about this passive fund and active fund. Well, can I just correct you on that fault? This does not enable them to particularly become an active fund. The purpose of this bill does not address that issue. This is about putting an intermediary between New Zealand Super, managed by the Guardians, and what they ultimately have invested, right? So we're all on the same page, hopefully, with that aspect. Related to that, at the present, the board or the Guardians cannot delegate or cannot grant powers of attorney. They cannot appoint an investment manager, and they cannot appoint a custodian. Now, I've got to say to you, this is absolutely unusual for funds not to be able to do this. So what this bill does is to again provide normal operating rules.
Andrew Bailey.
Thank you. Normal operating rules for funds such as a massive successful fund such as New Zealand Superannuation. Now, the second thing that this Part 1 deals with is about protecting the guardians against ultra-vires acts that they may undertake. So this means that if, for instance, the guardians, through the fund manager, enters into deeds, contracts, agreements, all the normal thing that you expect them to do, and for some reason they're deemed to be ultra-vires, this clause deals with this under 49A to permit those activities, those transactions to take place and not be subject to a court challenge, provided, and this is the overrider, provided that those transactions were all entered into in the normal course of event and there was nothing unusual to the extent of the activities that were undertaken. Now, the third thing that this Part 1 deals with is that it confirms that the fund investment vehicles are not subject to the Official Information Act 1982 and the Ombudsman Act 1975. And again, we've heard a bit of this earlier on from the opposition. So just to be clear, what this bill provides for is that the FIVs are not subject to both those scrutiny, both the Ombudsman or the Official Information Act. But the guardians still are. So again, there we got is a comprehensive set of measures that will mean that these fund investment vehicles can be put in place like virtually any other fund in the world, that they can invest in a range of equities, debt instruments and real property, albeit that they cannot control the equities that they hold, because as I noted before, they would have a huge dominant effect. And just to give you that context, that final point, if you look at the range of New Zealand investments that the New Zealand Fund is currently invested in, the highest investment they've got is Z Energy at 20% and Metro Life at also at 20%. All the rest are around about 10 and 8% of the New Zealand stock market. So I think this is a very good piece of legislation. It brings the New Zealand Super Fund up into modern standards of practice, and on that reason, I commend it to the House.
The Honourable David Parker.
I just want to respond to the